Assalamualaikum, everybody. Ahmed Susi here, the Interim Executive Director of CAIR Arizona, and welcome to our first Know Your Rights presentation for 2021. I'm excited to kick off the year with employment discrimination, which is probably our #1 complaint in our community. And as the attorney, it's my job to defend the community, and I'm very grateful that we have such generous donors that allow us to do pro bono services. But the other aspects of CAIR Arizona is to make sure you're educated and you know your rights, because sometimes it's a situation where you don't even know to call CAIR Arizona. And this presentation is, we're going to cover the basics, but we're also going to get into some more advanced stuff. So if there's something you missed or something that you want to ask, feel free to reach out to CAIR Arizona. Our presenter too, who I'll introduce in a couple of minutes, is an attorney who practices employment discrimination. So there are definitely a lot of options for you here in the Valley. But one of the things I do want to plug is we do have an employment discrimination 101 video on our Facebook. Like I said, we're going to cover the basics here as well. But if you want to get more of an introductory video, we have that on our Facebook. But as always, feel free to reach out to us. But let's get to our main event, our presenter. I am proud and happy to have a community member and an attorney who does employment discrimination, who offered to help us and break down employment discrimination. I'd like to proudly introduce Shifa Alkhatib. Shifa, how are you?
Hi, good. I'm happy to be here.
Shifa is an attorney with HMK Associates. Is it? HKM, I apologize for that. HKM Associates. Shifa, you do employment discrimination, but let's just get a little bit in your background. Before employment discrimination, what did you practice?
I practiced criminal defense for 5 years, and now I practice employment law, and we represent employees only in their employment discrimination matters.
I think that's important, something you mentioned, because a lot of people do employment discrimination. Not a lot of people do it for the employees. Sometimes it's only for the employer, and everyone has rights, but we want to make sure that Muslim employees and anyone who's discriminated have robust representation. And Shifa, to me, you are one of my role models. I come to you for questions. I'm a young attorney, you're an experienced attorney, so I'm happy our community has such vigilant advocates on their behalf. But Shifa will be doing this presentation, and as I said, if you see something here that you want more information on, you can always give us a call. Shifa, I know your phone number is on the presentation, but Shifa also does consultations, so there's definitely a lot of resources out there for you all.
Thank you, Ahmed. Would you like me to share my screen?
Yes, please. Let's.
All right. Give me a second.
Take your time.
Okay.
Alrighty.
All right, so thank you for that nice introduction. As Ahmed said, my name is Shifa Alkhatib. I work for HKM Employment Attorneys. So we're a nationwide employment firm, and I am the attorney here in Phoenix. We represent employees all over Arizona. Primarily, I get calls from Phoenix, but we are happy to help you in any of your employment needs. Today, we're going to talk about mostly discrimination. We do handle other employment matters. And so you're welcome to call me with that number on the screen. You'll get my staff and they'll set you up with an appointment. But today, for purposes of the PowerPoint today, we'll go over what your rights are if you are discriminated in the workplace. Like Ahmed said, there is a 101 presentation already posted. So I'm going to briefly cover what your rights are, but I'd like to go into what you can do if you are discriminated against, who you go to, who you can call, what paperwork you can fill out, and what you can do in the workplace to protect your rights. So with that being said, let's get started. So I started this first slide with the EEOC. So the EEOC is the Equal Employment Opportunity Commission. And why they are so important is because if you have any sort of discrimination claim, you can't just go to court and file a lawsuit. You have to go through the EEOC. So they're essentially a gatekeeper. their purpose is also to protect your rights in the workplace. Today, we're dealing with federal law mostly. So there are state laws that may be different. There are some state laws where you may not have to go through the EEOC, or you may not be covered under federal law, but you are covered under state law. So again, if you feel like today we didn't cover something that you feel like you have been discriminated against, please make sure to call an attorney or even call the EEOC to make sure you are being heard. One thing I want to know is that we are dealing with employees or prospective employees. A lot of times, if you are an independent contractor, you are not going to be covered by these federal laws. So it's very important to note that, but that shouldn't discourage you from calling an attorney or inquiring about your rights, because again, you may be covered by some state laws. But a lot of the time, we actually get people that are misclassified, which means they are considered an independent contractor by their employer, but they're doing all the things an employee would do. And that's called misclassification. So if you feel that you may be misclassified, it's also important to call an employment attorney or also go to the EEOC. They may tell you, okay, you're actually an employee. So what the EEOC does is they investigate complaints of discrimination at work for if you were discriminated against because of your race, your color, your religion, sex, gender discrimination, your national origin, age, or disability. And what the EEOC does is once you submit a complaint to them, and we'll go over that process at the end of this, but once you submit a complaint to them, they will investigate. And so they have employees that are hired as investigators. They will take your information, they will submit a charge, which means they will take the information down of, what happened to you at the workplace, why do you feel you're being discriminated against, and they'll put that into a piece of paper. That will then go to the employer 10 days later, and there'll be a charge of discrimination. And so what the EEOC does is they actually investigate the charges. They can hold hearings, they can attempt to mediate, and so they are able to do a number of things. One of those could be to get you a monetary settlement, to get your job back. That usually doesn't happen, or to even change policies at the company. So a lot of times we get people that ask us, do we need an attorney to go through that process? And you don't. You can definitely do that alone. There are some situations where having an attorney is tremendously helpful, and we'll get into that later as well. So let's talk about race and color discrimination. There's going to be discrimination. There could be discrimination if you are applying for a job, but you're also an employee. So if somebody is, let's say you have an interview and it's clear that they're not going to hire you because of your race, that is still discrimination, even though you're not an employee at the company. And so you can still file a charge of discrimination with the EEOC. I'm going to focus mostly today on employees because that's, the bulk of the calls we do get. And so some of those examples would be, let's say you are, working for a company and you have another employee that makes a racial slur or, makes a derogatory remark about your race. That's going to be considered race discrimination and harassment. But something important to note is, the law is not black and white. And so a lot of times people ask us, okay, this happened, is this race discrimination? Most lawyers are going to say it depends. And so they're going to ask you, what are the circumstances around what happened? So if you have somebody that made a comment that was, let's say, annoying, or it was a isolated incident and it wasn't extremely serious, well, the courts are going to frown upon that, but it's not necessarily illegal. It really has to rise to the level of making it a hostile work environment, something that's intimidating to people or offensive to the reasonable person. And so what I tell people is, if you have been discriminated against and it was one time, make sure you complain to HR, because let's say the person said something that everybody else doesn't think is racist, right? But if they're making multiple comments, well, then there's a pattern, and you have continuously complained to HR. And so what that does is it protects you. Let's say in the future you're fired for a complaint. You know, that's going to protect you to show that, look, you have gone to HR multiple times because of this person, and now at your last complaint, you're being fired. Or that person complains about you for some reason. So it's always good to document. My number one tip is just document. Go to HR. Do not, sweep it under the rug, because if you come to HR 6 months later and say, hey, 6 months ago I was discriminated against, it's going to be very hard for them to take it seriously. But not just that, it's going to be hard for you to say that that was so offensive when you're not complaining about it until 6 months later. Now, it's different if it's continuous harassment and somebody is continuously making comments and you finally have had enough and you make the complaint. Yeah, go ahead.
Sorry, so one thing I do want to jump in, and you hit the most important piece of advice I give anyone: document everything. Paper trail is the answer. One thing though that's extremely important is not only write down the incident, but if it was said when people were around you, write down who were there as witnesses, because even if you have it written down, that person might say, no, that wasn't me, but you could say, hey, John, Ahmed, Shifa all heard this. Then that's a stronger case. Now, unfortunately, there are situations where sometimes witnesses might be like, hey, listen, I didn't hear that, or I didn't hear this, but it's what you could prove, not what has happened. So
absolutely. I mean, and people are people. People are going to lie too. You're going to have witnesses that don't want to come forward, or they feel like their job is at jeopardy and they don't want to speak up for you. But I agree. Definitely document everybody that was there, the day it happened, the time it happened. Because when you go to, the employer and you say, look, you did X, Y, and Z, and these are the times and dates, and these are the witnesses, that's going to be a lot stronger case than, hey, a couple months ago this happened and, nobody else was there. And you never complained about it before. So, and we'll get into, after I cover kind of all the categories, does it make sense to quit? Will I be fired if I make a complaint? And so we'll get into all of those shortly. There are some times where there will be policies at a job that may impact a particular, people of color, or a particular religion, which we'll get into. And so sometimes even policies or practices at a company can be discriminatory. It doesn't have to be just somebody making a comment. You could also be discriminated against because they do not want to promote you because of your race. And again, it can't be just assumptions. We have something called circumstantial evidence, which means, there's a lot of things, nothing points to it exactly, but there's a lot of things that could lead you to that conclusion. And so if, the company is continuously not promoting people of a certain color, or, there were comments surrounding it, or same thing with gender, they're only hiring males, there's going to be a pattern at the company if something like that is true. So let's go to religious discrimination. So, making comments about your religion, treating you differently because of your religion, offensive remarks, that is all going to be religious discrimination. Or firing somebody because of their religion, deciding not to hire somebody because of their religion, even, refusing to promote an employee because of their religion, or paying somebody less. And these can actually apply to all the categories, dismissing somebody because of their religion, deciding not to hire somebody, because of their sex or their color. And so a lot of these overlap, but some of these, you may need a higher standard to prove in court. That's kind of where, the attorney's job comes in. One thing I wanted to know is reasonable accommodation. Let's say, for example, let's say there's, people making comments that could be harassment, but also there's you requesting a reasonable accommodation from your employer. So for example, you want to, you have to go pray every Friday at a certain time, and you've asked your employer, your boss, whoever it is, and your workplace allows flexible scheduling, or they allow modification to their policies, they should accommodate you. Where it's a little tricky is when you're dealing with small employers. A large company, it's going to be very hard for them to say, hey, it was a burden on us. Because if it's a burden on the company, they have an excuse. They're going to say, it was a very hard burden on us to cover, Ahmed's position for 1 hour every Friday because nobody could do his job, or we don't have enough employees. Larger companies, it's going to be difficult for them to say that. But if you're at a company with 20 people and everybody does a different task and nobody can cover you, and it's just absolutely impossible for them to allow you to leave that 1 hour, I still think you should ask for the accommodation and let the employer respond to you, and always follow up in writing of, hey, yesterday you told me you couldn't accommodate me because X, Y, and Z. Let them respond to you, but it's likely that if it is a burden on the company, they are excused from accommodating you.
One thing, Shifa, and pretty much every time I'm going to say something about a writing story, there's situations where sometimes your old, that people call us that their old manager let them have this accommodation, but new leadership is there, and if it was like, well, my manager let me do this, why didn't you? And they can be like, well, we don't have any documentation, he didn't follow the procedures, this or that. So even if it's something where you just like, I would have it as official as you can, so it just protects you. So
right. So like if your last boss let you do it, but he never did anything in writing just because he just didn't, it doesn't mean that you can't be accommodated. Yeah. Even if they say, hey, our policies don't allow it, it doesn't matter. Can they accommodate you whether or not it's a policy? Maybe they need to change their policies. But really the courts look at, is it a burden on the company? And it's, again, when you're a small employer, it's going to be very different than when you're a large employer. Something else to know is that you have to, in order to fall under federal law, you have to have at least 15 employees. So there may be some people that call you that may not fall under, protection of federal law, but there may be state laws that they fall under. And that's where, it's really important to call an attorney or call somebody to figure out if you have rights. You have any other questions about that one, Ahmed? Or
nope, just write everything down. That's
I like your story. I like your stories. I think that's helpful. So the presentation is not as bookwormy.
No, not at all.
Okay, so sex discrimination. This is not just because you're a female or a male. It can also be sexual harassment. It could also be pregnancy discrimination. Pregnancy discrimination can fall under sex discrimination. It can also fall under disability discrimination. Just depends on your case. But let's say for sexual harassment, your boss or your coworkers or even your customers are making derogatory comments or jokes or gestures at you that are related to your sex or that are related to your status as a pregnant woman or a nursing woman. Well, that is sexual harassment. It doesn't actually have to be sexual in nature, but it has to be related to your sex. So, the courts now say simple teasing is not enough. An isolated incident is not enough to show sex discrimination. But harassment is illegal when it's so frequent and so severe that it really affects your job. And let's say you're scared to go to work or you're intimidated to go to work. But again, just because I'm saying an isolated incident may not be enough, it does not mean you shouldn't report it. Always report everything to HR. If you do not have an HR, report it to a supervisor, report it to whoever is the next level above you. The good thing with sex discrimination is you do not need, under federal law, you need 15 employees. For sexual harassment in Arizona, you only need 1 employee. So if you don't fall under federal law, you'll fall under state law. And so it's really important to note that as well. Let's say you're fired because you're a female, or you're denied a job promotion. This is one that we hear a lot. You know, the males keep getting promoted over females. Again, you have to be able to show that it's a pattern with the company, because sometimes you may not be promoted, but it could be for other reasons that the company is saying is non-discriminatory. But if you're able to show that there's this pattern at the company that they continuously hire or promote males over females, you may have a case. Right. Okay. National origin discrimination. So again, this falls under a lot of the other categories, but treating somebody different because of where they're from. So you can also treat somebody differently because of where their husband or wife is from. Sorry, you cannot treat somebody differently because of where their husband or wife is from. And so if there's a policy at work that affects only, negatively affects only people of a certain national origin, or same thing for religion, only affects people with a certain religion, that's going to be discrimination. And so, here it says English fluency only required if necessary to perform job effectively. So let's say there are a lot of times where people will discriminate against you because of your accent, or because maybe you're not fluent in English. That is discrimination, unless they can prove that English fluency is required to perform the job effectively. And so that's going to be on the employer to prove that. I can't think of anything off the top of my head where it would be. I can't think of any examples, but I haven't actually had any calls about that. How about you, Ahmed?
I've not had English fluency as one thing, but we definitely get calls about people being harassed because that English is their second language. And one thing about national origin that I kind of realized when I started working here with CAIR is, even if the people are saying stuff to you slurs and it's not where you're actually from, it still counts, right? So there was an example where there was this Hispanic person, and the person was calling him a Middle Eastern slur, like go back to X country, and the person was like, I'm not from the Middle East. But just because they were using national origin they were discriminating because of that national origin, it is enough. So one of the things I usually tell people, that when people have this bigotry or hate in their heart, it's kind of like Baskin Robbins. They just, every flavor to them, they're taking all 32. Right, so it doesn't really matter. Yeah. If you're this flavor, they're gonna get you. So
right. And again, if that happens, even if you feel like, okay, well they weren't talking about me because I'm not from X country, report it. And it is very hard. I understand people sometimes have problems reporting conduct at work because they feel like, hey, I'm gonna be like this tattletale and I don't want my job to be uncomfortable. Unfortunately, if you want anything to change at work, you do have to report it, and you do run the risk of being terminated, and that's something we'll talk about, or being treated differently. And so that is something you're going to want to document as well. So age discrimination. Let's say, I don't get this one comes, I don't get this one too much, but typically it comes with when the person's also being terminated. So for example, repeated questioning of your retirement status, accompanied with, encouraging older employees to resign or terminating older employees. That is all age discrimination. So you can't continuously question somebody, hey, when are you going to retire? Hey, I think you should resign, if we're forcing you to resign, that's age discrimination. Or, just comments about people's age, and that typically will come in when somebody is, let's say they're like 75 or 80, or they may appear to be older, and they're working with youth, or a younger generation. They may get comments about their age. That's illegal. You cannot continuously remark about somebody's age in a derogatory manner. This would fall under the Age Discrimination and Employment Act. So You do not need a notice of right to sue from the EEOC, and you can file your lawsuit in federal court after after 60 days after you file with the EEOC. So we'll talk about timeframes. Sometimes these cases go through the EEOC for a very long time, and so that's something that I talk to people about. Is, hey, once you file a complaint, it may take 6 months to 3 years to resolve, depending on what you're seeking. The biggest one I see here is disability discrimination. So this could be, and the biggest one is reasonable accommodation, especially now with COVID. A lot of people are requesting to telework. And I think even before COVID, people were requesting to telework, and a lot of companies weren't allowing it. But now, after people having to stay home and telework, it's very hard for a company to say, no, actually, you need to come into the office, when I was working at home for 6 months with no problem. And when we get into COVID, the law is changing so much. It does fall under disability discrimination, but we don't really know what the courts are doing with that yet. But for example, let's say you work at a job where you are in a wheelchair and you need to reach something up very high, and you let your employer know, hey, I can't reach that because obviously I'm in a wheelchair, I need an accommodation. Either can you put me on a job where I'm doing things at height level, or whatever your request is, the company is required to have a discussion with you to see if they can reasonably accommodate you. Sometimes you may need a doctor's note. So let's say it's, I can't work from 8 to 10 a.m. because of, my disability. This is what happens to me from 8 to 10 a.m. They'll say, okay, can you provide us with a doctor's note or fill out this reasonable accommodation paperwork, which the company has a right to do. So once you fill that out, if the company is able to accommodate you, they have to do it. But let's say they can't accommodate you. Let's say, again, it's a small company. And between 8 a.m. and 10 a.m., there's no one else to cover you. And they say, listen, if you don't come in at this time, we'll have to close the store, we're gonna lose money, it's gonna be a burden on us. Legal term they use is undue hardship. Would it cause a difficulty or expense that's just so high that a company can say, no, we can't do that? And so again, when you're working for a large company, it's always harder for them to say no because they do have a lot of employees. They may have a lot of things in their grasp to work with. When you're with a small company, a lot of times if you're going to be either out every day at a certain time, or you have to be out for a week, and it's going to be an undue hardship on the company, they may not have to accommodate you. Or for example, let's say you need you work construction and you need a light duty job because you hurt your back. If they don't have any light duty jobs, there's not really much you can do. Typically they will, there's going to be other jobs like sweeping or, whatever it may be. But if they don't, they don't have to accommodate you because they're just not able to. So I don't know if there's any examples that you can think of, Ahmed, that have come up.
No, but I do think that disability discrimination sometimes gets a back seat in our minds of wanting to advocate for people. So
yeah, and it doesn't necessarily just have to be something that you could see with your eyes, like somebody
exactly.
being in a wheelchair, or it could be a mental impairment.
Yeah.
You could have, a mental health disorder that doesn't allow you to work nights, let's say, and your job, they have day shifts, but they don't want to put you on it. That's discrimination because they're able to put you on the day shift, or vice versa. So, always ask for an accommodation. Again, always document, do it in writing. If they say no, ask them why, and get that in writing as well. Sometimes if you ask for an accommodation and they say no, and you're not able to do your job, they may terminate you. You may still have a claim against the company for disability discrimination if it's found out later, through attorneys or interviews, that they were actually able to accommodate you. I'm gonna skip that one. Okay. So do I have a claim, and, should I hire an attorney? So I briefly, I went over all the categories, but that's a very brief synopsis. There are some other categories that fall under federal law. I think those are the main ones. And there are other examples that we could give you, but then we'd be here all day. So today I really wanted to focus on, do I have a claim? Do I need an attorney? What should I do if I quit, or what should I do if I'm fired, and how to file a charge. So do I have a claim of discrimination? And the answer is going to be, it depends, maybe. But what I would say is keep records of everything. If you have been, let's say last month you were sexually harassed at work and it happened one time and you decided not to report it, but then a week later you were sexually harassed again, whether it be the same person or a different person, again, keep a record of it. But at some point you're going to need to report it, because if you want, something to be done. Because let's say you are sexually, and I'm using sexual harassment just as an example, but let's say you're sexually harassed by a fellow employee and it happens, let's say 5 times. And then you decide, you know what, and I'm kind of getting ahead of myself, so we'll go back to this one. But let's say, it happens 5 times and you're just like, I cannot take this anymore, I need to quit. You're not really going to have a claim of liability against the company because, one, they probably didn't know. If it's a fellow employee, you need to go to HR, you need to notify the company. If you notify the company and they either don't do anything, or they terminate you, if they terminate you, that's retaliation. If they don't do anything and you're still in this bad environment, you can quit. It's something called constructive discharge, where you had to resign because the working conditions were so bad. And there's a lot of case law around this, and it's kind of tricky, because if you stay at a company too long, after something happens, they're going to say, well, look, obviously the conditions weren't intolerable. You stayed there another 2 months, after the incident happened. Or if you leave too quick, they're going to say, look, you didn't let the company remedy the situation. You didn't tell the company. And when you did tell them, you left the next day. So you didn't give them time to fix it. And so it's very tricky on, do I leave? When do I leave? I always tell people, of course, the decision is up to you. If you cannot stay there anymore and it's really, affecting your mental health or your physical health, or, it's, you just can't take it, then, you're going to have to do what's best for you. And if quitting is the best for you, then you need to do that. But when it's a fellow employee, you need to go to HR, or that there's no way for the company to know. I had a situation where it was a fellow employee that said something derogatory to someone, but her supervisor heard it. And that supervisor should have done something, especially if they are seeing the conduct. So let me give an example of if it's a supervisor. If your supervisor racially discriminates against you and says, I don't like people that, are from this country, or I don't like people, of a certain color, that's discrimination. And whether or not you go to HR, that's most likely, there's going to be liability on part of the company because the person was in a supervising position. Still, I always tell people, go to HR, make the complaint, because that person can deny it. People lie all the time. So again, always go to HR and document what happened. But if you end up going to HR and they fire you, that's retaliation. So it's something called protected activity. So anytime you're making a complaint about one of the categories we talked about, like you were discriminated against because of your race and you went and told your supervisor, or you told HR and the next day you're fired, you will have another claim of retaliation. So you'll have race discrimination and retaliation. So, do I have a claim? It really is going to depend on the situation. It depends if you quit, if you were fired. But, I have people that say, hey, do you think I need an attorney? I'm sure the same thing, Ahmed, you get calls of people asking you like, hey, do I need an attorney? Who can I talk to? You do not need an attorney to go to the EEOC, but I always think it's helpful to at least consult with an attorney. They will at least be able to tell you what your rights are. They will tell you what your deadlines are. They will tell you what they think of the case. And so if they can't take the case or you don't want to hire them, you'll at least know, okay, this is the likelihood of me prevailing. So you don't actually have to file a lawsuit. You can go just to the EEOC. So I have here, when should you consult with an attorney and why and when? So pre-filing, that means before you file with the EEOC. Or if you do the intake and they file the charge, you can still get an attorney during that process. So let's say you're in the middle of the process and the EEOC says, hey, we want to set you up with mediation with the company. You can get an attorney then. Once the EEOC is done investigating, that investigation will consist of interviewing you. They will record that interview. They will interview the employer. They may interview witnesses that you give them. And then they'll have an attorney that will take a look at the case. Once they are done, they will give you something called a right to sue. That letter will say, we found that there was discrimination, we didn't find there was discrimination, or we haven't had enough time to investigate. It doesn't matter what they decide, as long as you get that letter that says, you've gone to the EEOC, we've investigated, and now this is your right to sue. Once you get that, you only have 90 days to file a lawsuit. I would say it's very difficult to find an attorney within those 90 days because most attorneys are going to want to spend some time really understanding your case, hearing if you have witnesses, going through that EEOC process with you. There are some attorneys that will take it. Some attorneys take it on a contingency basis, which means you only pay them if you get paid. Some you'll have to pay hourly. And so, if you plan to get an attorney, I would do it well before you get that document that gives you the right to sue.
One thing I'll add here, even though I am the only attorney for CAIR-Arizona, I'm still here to answer all your calls. So even if we can't represent you, always feel free to give us a call, just so, like you said, you have a free attorney who could at least listen to your case and say, well, we might not be able, CAIR might not be able to take this case. Well, let me give you Shifa's number. Let me give you this person's number. Let me give you this person's number. Too many times I get calls from people who waited too long or are too far in the process for me to be like, well, I think we could help you, or maybe this person could help you. So, CAIR-Arizona is free. It's because of our generous donors. So give us a call at the minimum, even if you want to find an attorney, right? I've gotten calls where people just say, hey, Ahmed, I want you to help me find an attorney. So, at the minimum, CAIR-Arizona is here for you. But I know Shifa does consultations as well. And as the employee, you gotta expect that your employer doesn't just have one attorney, they got a whole firm. So you wanna at least make the playing field as level as it can be.
Right. And, one thing, I mentioned go to HR, but also follow company policy. If the company policy says, go to your supervisor, go to your supervisor. If it says go to HR, go to HR. Again, you can even call an attorney during this process before you quit, before you're fired. When the first incident of harassment occurs, or the first, rude comment or racist comment occurs. You can call an attorney and they can say, hey, this is what we think you should do. This is what we should tell, you should tell your employer. You may get comments of, trying to give you other examples of like, older employees are just set in their ways, right? And they make terrible managers. That's age discrimination. Women don't belong on a construction site. That's age discrimination. You have to look at, does your employer, show a history of showing bias towards people of your race? They may not have made a comment to you, but maybe you didn't get that promotion, and you start to think like, okay, this person has done this before. I could tell they were treating people, in my race or other races differently. So those are just always things to be aware of. But I understand sometimes why people don't go to an attorney. It does cost money, and that's hard, if you're thinking you're going to lose your job. But I would really suggest you consult with an attorney because you may have a strong claim. All right. Okay, and I kind of went over this, but who's doing the harassing? This is important because If it's a fellow employee, like I said, if it's an employee and even if it happens 3 times and there's no one else around and you say, okay, well, I'm sick of this, I'm leaving, now I want to sue the company for discrimination. Well, you really can't, because the company didn't know. They have no ability to know because you didn't report it. They're not in a supervisory position, so there's no liability there. You have to have either reported it to a supervisor, to HR, or they should have known about the harassment, and they failed to take the appropriate action. Let's say, for example, you do tell HR and HR, puts that person on leave or terminates that person that was doing the harassing or making the discriminatory comments. Well, I have people that say, hey, I was discriminated against today, but they fired that person that, made those comments. Well, the company has done what they needed to do, so you don't really have a claim against the company anymore. They've taken action and they took the appropriate action. If it's your supervisor that's doing it, the company is going to be automatically liable for the harassment of the supervisor. And they're going to be liable for the employment action if they, terminated you, or they failed to promote you, or you lost wages. And so, it's going to be very different if it's a fellow employee or a supervisor, or even a customer. Let's say a customer is, making racist remarks. If your employer doesn't know, it's going to be very hard to hold your employer liable. Okay, so let's get into how we file a charge. So I've been talking this whole time about the EEOC, and again, it's a very easy process to do on your own. Something very important to know: just because you go through this online process I'm going to show you right now does not mean you have filed a charge. That's very important because there are deadlines you have, which we'll get to at the end. But it's just an intake questionnaire. So you have to wait for an appointment, which right now I believe are 1 to 2 to even 3 months out with the EEOC. So you'll go to this website. You can also, Google EEOC, how to file a charge, but you'll go to this website and this is what you will see. So you will see this. You'll want to go to filing with the EEOC. You'll click on that. It'll take you to this page. So I went through it and I just made some random clicks, but this is probably going to be the most popular one: business or nonprofit that I applied to, I work for, or worked for. If you work with any of these other agencies, you'll need to click those buttons. And then it'll take you to this page. So right here, it says submitting an inquiry is different from filing a charge of discrimination, which means what you're doing right now is you're submitting an inquiry to get interviewed. You have not filed a charge of discrimination. I will show you what that charge looks like. It's something you're going to have to sign after you do your interview with the person. So I have people that say, hey, my deadline to make a complaint is next week, but I already talked to somebody at the EEOC. Well, you may have talked to somebody, but you didn't file anything and you didn't sign anything. So you have not filed a charge of discrimination. Attorneys actually don't have to go through this process, so we can file the charge on your behalf. So if you're getting close to a deadline, I definitely suggest you calling an attorney, because you may not get a call back from the EEOC, within 2 days. It'll then take you to this page, so you can watch this tutorial. It'll just tell you, the basics of filing with the EEOC. Then you'll hit next. It'll take you to this. So it says timeliness. You have 300 days from the date the discrimination took place to file a charge. If there's a state law equivalent to the federal law, you have 300 days. If there is not, if it's only a state law, you have only 180 days. That's something you may not be familiar with if you're not an attorney. So it's very important that you either ask an attorney or file it within 180 days, because then you're meeting both deadlines. So I always tell people, file it right away. If something changes, let's say you're still at your job and another discriminatory conduct occurs, you can amend your complaint. So you can call back the EEOC and say, hey, I want to add something. This is what changed.
One thing to add there, 2 points. The first one is every single incident has its own
correct
timeline. And sometimes, because we get calls for people where it passed that 300 days, it's still evidence, right? So you might not be able to use that as the claim, but as long as you have one within that time period, you can say, look at all these other incidents. So,
yeah. So let's say something happened, 3 years ago. It's not going to fall under the law. But let's say it's happened every day for 3 years. That's very different, because then you can prove something called the continuing action. And so it may fall under the statute or the law. But yes, if you, if two things happened 1 year apart, you should still let them know about it. But that first one is probably not going to be something that you can file a lawsuit under. But it is evidence, like Ahmed said. So you'll put the most recent date something happened, and don't worry, once you get your interview, you can tell them everything that happened and they'll go through all the dates with you. But for purposes of this, they want you to put the most recent date. It'll then take you to this page. So it says, I believe I was discriminated against because, check everything that applies. If you are not sure, it's okay, just check the box. Because this is just an intake. This is so that when the person that calls you is doing the interview with you, they can look at, okay, let me see if I covered everything. Let me see what boxes they checked. So it's very important that you check everything that you think. If you're not sure, that's okay. You just need to check something. Most of the time, if you're terminated, you're gonna then also hit, I contacted, can you see my mouse, Ahmed, on here?
Yes, yeah.
I complained to my employer about job discrimination. So if you complain to them about, let's say, race discrimination, you're gonna hit race. And then if you were terminated, that's retaliation. You're gonna hit retaliation. Or if you were demoted, or you lost wages, or something happened to you because you complained, that's retaliation. And those are gonna be two separate claims if you were to file a lawsuit. So it's very important that you check both of those. It'll then take you to this page. The reason this is important is because if a company has less than 15 employees, they may not be covered under federal law, and so they're going to want to know that. Again, if you're not sure, you can put I'm uncertain. If you think it's at least 15, then you'll want to check 15. Again, this is so that they can ask you. They may, if you say less than 15 employees, they're going to interview you because to make sure they're covering everything. But you may not have a claim. Then where did the discriminatory action occur? This is important. Obviously, it's, I think if you're in Arizona, it's most likely going to be Arizona, but sometimes you are traveling for work. And so let's say the action happened in Nevada or happened in Utah. This will, it'll route your complaint to the appropriate office. So they do have an office in Nevada. They do have an office in Arizona. If there were multiple acts of discrimination, I would probably put where it happened the most or your home office, which is going to be Arizona if you're watching this. All right, then it'll take you to this page. This is a summary of your responses. So you'll just be able to double check. So this is a sample I did, and these are all the things that I put. If you messed up, I believe you can go back. You can hit the edit icon right here to the at your response. Then you go next. It'll take you to this page, and then it'll tell you your situation appears to be covered by the laws that the EEOC enforces. So again, if you are saying there's race discrimination and there's less than 15 employees, it may not be covered. So I don't know if they will ask you to interview with an EEOC representative. So that's why it's important. If you're not sure how many employees there are, don't put less than 15. You can put, I don't know. Again, they warn you here, submitting this is not the same as a charge of discrimination. So you'll go to the next page, and then it'll take you here. And this is where you will register to continue your filing. So you'll make an account, and you'll be able to set up an appointment with them. So what I wanted to show you is this is what a charge of discrimination looks like. So unless you sign this piece of paper, you have not submitted your charge. If you do an interview with the intake person, until they have you sign this, you have not submitted your charge, and you're not, you didn't, your time is still running. So if it's, 3, 4, 5 months out, but let's say you're getting close to 300 days, make sure you follow up with them. This is not something that you will fill out. This is something that EEOC will fill out, but it's good to be familiar with what it looks like. And so your information will go up here, your name, street address of the employer. This is where the boxes will be checked of what the discrimination is based on. Here are the dates. And so you'll get a copy of this and you'll be able to review it before you sign. So you'll double check the dates, double check the discrimination here, and then they will have a summary of what happened here, and you'll want to double check that as well. The reason this is important is because if you decide to file a lawsuit and you did not bring up the claim in this charge of discrimination, you cannot bring it up in your lawsuit if you're time barred, if it's past the 300 days. So for example, let's say you believe you were discriminated against because of your race, but also because of your religion, but you didn't mention anything about your religion, and you remembered later, and you remembered right before you're going to file a lawsuit. You have to file an EEOC charge. So you can't just bring it up in the lawsuit. And that's why the EEOC, acts as a gatekeeper. So they will have you sign it here. Sometimes the EEOC will have you notarize it. Because of COVID, I think they've put those on hold right now. After you file your charge, like I said, you'll go through an investigation with the EEOC. You'll be signed an investigator. You can, there'll be a portal. So when you make an account, you can actually sign in and see what the status of your case is. You can submit documents. Let's say you have emails, you can submit them onto that portal, onto that website. Within 10 days of that charge that I just showed you, the EEOC will send a notice to your employer. So if you're still working there, they're going to have access to that notice. So it's very important that if you're still working at a company and you know that they got the notice and you start to feel a change at work, you need to update that complaint. And you need to say, I am being retaliated against because I submitted a charge of discrimination. Maybe they're demoting you now, or maybe they're making you, pick up dog poop. You never had to do that before. They're doing things that are either not part of your job role or things that you wouldn't necessarily do to punish you. And that is unlawful. So, you can ask for your right to sue early. So let's say you give the EEOC 180 days and, you don't hear anything. You can say, hey, I want to go to court and file a lawsuit. Can you send me my right to sue? They typically will do that. But if you don't have an attorney and you're planning on getting one, I wouldn't ask for it until you talk to your attorney. Because if you only give the attorney 90 days to file a lawsuit, they may not want to take your case. We talked about that. We talked about the deadlines. So there's a local agency called the Arizona Civil Rights Division, and they're through the Attorney General's office. So they actually have their own anti-discrimination laws that are, state-based. What happens is if you file a charge of discrimination with the EEOC, it's duly filed, which means you do not also have to file it with the ACRD. And if you file it with the ACRD, you don't also have to file it with the EEOC. In fact, they don't want you to. You only file it with one agency, and then they will file it on your behalf with the other agency. So sometimes the EEOC will send a case to the Civil Rights Division and say, hey, we want you guys to handle this, and vice versa. So again, one of the examples I gave earlier was sexual harassment. And let's say that company only has 5 employees. So now they're not covered under federal law. So they may send it to the Civil Rights Division, and you can file your claim in state court. So how to file your complaint with the Civil Rights Division. Again, the biggest reason some people file it with the Civil Rights Division is time. Let's say you are 1 month out from your deadline. The EEOC is very backed up. And so if you are not able to get an appointment that you think is quick enough, you can go to the Civil Rights Division and file your at least, put your information here, and they will give you a call back. And typically they call you back sooner than the EEOC. So you can also go to this local agency. So what you do is you'll go to this website, azag.gov/civil rights. It will take you to this page. You'll click this large box that says file a civil rights complaint. You'll be redirected here. Again, this is an intake questionnaire only, so you are not actually filing a charge. And so you'll put your information in here. And then you will put the company information here. You'll give a short summary description here. Same thing, date of last incident. So if it happened yesterday, you're gonna put, yesterday's date. Is it ongoing? So has it been happening, once a week, every week for the last 3-4 months? So you'll put yes. Again, this is just an intake, so it's not a test. If you get the answers wrong, that's okay. Do it to the best of your ability, because they will have somebody be interviewing you, and they'll get the information from you. You will put what kind of discrimination it was. So you can see here, there is housing discrimination, public accommodation, voting. That's not what we're going over today, but just so you know, that's available to you. This is where we're talking about today, which is, the employment discrimination, right here. And so you'll check the boxes that apply. Do you have an attorney? They'll want to know, because they'll contact your attorney if you do, and they'll get the information from them. Is there any legal action pending? Have you tried basically to sue them, or, any other sort of legal action? Anybody, if you contacted the EEOC, you'll list that here, and any comments you have. And then here, you're signing that everything above is true and correct to the best of your ability. So once you do that, and then again, an intake person or investigator will contact you. They will get your information. They will prepare a form that has your complaint, like the one that we saw earlier, and they will submit that for you. So again, just be mindful of your deadlines. Okay, so best practices. I can't stress this enough. Always go to HR or go to a supervisor, make that complaint. But what do you ask for? You can ask for an investigation. You can ask for discipline. You can ask for training at the company, apology, if you want to be transferred. What I've had happen is people, go to HR, there's an investigation done. HR may find that nothing happened. They do not have to tell you the results of their investigation. So if something happens again, go to HR and document, because HR may decide they don't believe you and they believe the other person, and that's fine. But that if it happens more than once, you're going to want to have documentation of that. Again, let's say you make a complaint and they don't believe you, but your work environment starts to become really, unbearable. That person is, doing the discriminatory conduct again, or, your supervisor is now giving you work that he wouldn't have given you before, or you are getting demoted. That's all retaliation. And so those are also claims of discrimination. So what are the remedies? So I always ask people, what do you want to get out of this? So you're calling me and you're saying, yesterday somebody discriminated against me, and what do I do? Well, it's, what do you want? Do you want to have that person, be terminated? Do you want to change the policy at the company? Do you want to sue the company? So again, if you go through the EEOC and then you sue the company, there has to be claims. So if the discriminatory conduct happened once, they never fired you, they fired the other person, you're not going to have any damages. And that's really how a case is looked at. If you want to change policy at the company, you may be able to do that through the EEOC or through hiring an attorney. But usually what we look at is, by the time I get the case, the person has been fired or they have quit. And so we look at, okay, what is the back pay? So from the date, they may have been fired, or the date from the discrimination date to the act of judgment. So until the end of the court case. They'll look at, let's say I was fired yesterday and my case goes to trial in 1 year. That's back pay. They'll also look at front pay. So if you lost future earnings. One thing to note is a lot of people get jobs immediately. Sometimes you don't, and that's lost wages. If you get a job immediately and you're getting paid more, you're not really going to have any lost wages. In fact, now you're making more, but you are required to look for employment. So you can't just be unemployed for 2 years because they will ask if you mitigated your damages. Have you tried to find employment? But those are not the only damages that you have. You have lost benefits, emotional distress damages, punitive damages. There are caps on those, but those are damages that, if you had pain and suffering, you can say, hey, I value my pain and suffering at X amount, or the jury wants to punish the employer, let's say $50,000, that can go to you. And then sometimes you can recover your attorney's fees. So if you are either paying your attorneys or you're getting on a contingency, you can still try to recover those fees. Let me stop sharing my screen.
Awesome.
So, I think the takeaway from all this is really document, go to HR, talk to an attorney, make sure you, like Ahmed said, document your witnesses. And I know it's very hard to go to HR when you still are working at the company, but really you're not going to see any changes unless you do. And if you're scared that they're going to terminate you, and if they do, you have a claim against the company. One thing I would say is not all cases, get lawsuits filed. So you can have an attorney contact the company and say, look, you violated my client's rights, and this is what we think the damages will be at trial. And some companies will settle with you before actually going to trial or filing a lawsuit.
The one thing I want to add right there is sometimes we get those calls from people who are still working there at saying, I don't know what to do. I don't want to file this lawsuit or a complaint with them. And it's always a personal choice.
Yes.
But when you're, maybe just because we work in civil rights, but it's one of those things that if you don't stand up, what's going to happen to the people who will come after you, and it's a personal decision, and you got to take care of your family. But sometimes it is as small as, well, we didn't realize this was an issue. It's a quick fix, or it doesn't have to be a Supreme Court case. But other times, and we talked about this in my 101 presentation. We talked about the Abercrombie and Fitch case, where it was a dispute about wearing a hijab, and the Supreme Court ruled 8-1 that Abercrombie and Fitch discriminated against a Muslim woman. So, it's one of those things, and she was. It was in an interview process where the discrimination occurred. So it's one of those things where I always say that you want to think about your community, right? And sometimes you want to say, I'm going to stand up, and other times you don't. So it's definitely a personal choice. At the minimum, call for help. CAIR-Arizona is here for you. Give me a call. I'm here for you.
I do free consults for these types of cases, so you are welcome to call me. My number is on the front page. And I'm happy to give guidance.
And I want to thank you so much, Shifa. Do you have any other parting words, or?
I don't think so. Hopefully that wasn't, too much information and it was clear. But, if anybody has questions, I'm always happy to help. Feel free to call me, whether or not you think that it's an employment issue or not. I'm happy to steer you in the right direction. But thanks for having me, Ahmed.
Thank you so much, Shifa. And I will always love to see local community members wanting to, help. And I appreciate you doing this, for us. And I think our community definitely will benefit from learning the complaint process, because even though that's something we recommend to do with an attorney, you could do it by yourself.
Yeah, absolutely.
The one thing I would add is, if there are other parts of the civil rights fields that you want us to have Know Your Rights presentations on, feel free to contact us. You saw just from the Arizona local page, the public accommodation, housing, voting. So there's a lot of stuff, and education is the key. But thank you all for joining us for our first Know Your Rights presentation for 2021. We have some more And Shifa's phone number will also be in the description if you want to reach out to her, but there's always our phone number as well. Thank you so much. Masalama.